In this video, we'll be talking about Chapter 1 of the book State of Exception from 2005 by the Italian philosopher Giorgio Agamben. I think this is a really fascinating book. It's also quite a challenging one, and so I thought I would take you through it slowly, chapter by chapter, and try to kind of unpack what Agamben is talking about. This book remains very relevant, even though it was written in 2005 and was initially responding particularly to 9/11 and the aftermath in the United States. I think increasingly we still see the currency of this book, as I'll try to suggest in a moment here. Now, I'm not going to touch on every single thing in this book. It's super complicated, but I just want to give you enough information so that you can read State of Exception by yourself and get a lot out of it and feel comfortable with a lot of the terminology. If we think of a state of emergency, we can see that this particular term crops up in most Western democracies in different formulations. And one of the things that Agamben wants to point out is that even though we might think of a state of emergency as something that a dictator might invent to rule with an iron fist, this particular procedure is actually something that originates in democracies. And so there is a kind of contradiction there, a paradox, which Agamben is fascinated by. Why do democracies need these seemingly extra legal measures? And as we find out, the state of emergency is both legal and not legal. It's kind of this weird borderland. So if we look at these different languages, in English we have state of emergency and martial law. In German we have Ausnahmezustand, which is basically an exceptional circumstance. Ausnahme refers to an exception. Notstand, note means a kind of dire need and necessity. And in French we have état de siège, so a state of siege. And those are just a few examples that Agamben provides. If we give some examples of these, we might think of more contemporary events. So think of something like Hurricane Katrina. This was in 2005 as well, so I guess not super contemporary yet. But often with natural disasters, the government declares a state of emergency and then can do things that it normally would not be able to do, like go into people's homes and things like that. Another example here, kind of a controversial one, if we think of Trump's border wall, so Trump's border wall, in 2019, President Trump declared a state of emergency, a sort of national emergency, in order to get funds for his border wall. And there were legal challenges to this because people said, well, is that really an emergency? Is that threatening the safety of the country? So that's kind of a controversial one. We can also think of something like COVID-19. How do governments respond to this? Are they allowed to lock down society? Can they restrict your freedom of movement? Can they tell you to wear masks and not to visit with other people? So this is something that pretty much every country in the world has had to deal with in relation to COVID-19. And I'm not going to take a stand on this, but I think this book should be fascinating for anybody who wants to think about these legal questions of what can the state actually do. As it turns out, most countries have some kind of provision for a state of emergency. For example, in Canada, where I live, we have the Charter of Rights and Freedoms, which spells out all kinds of liberties that citizens have. But the very first article says that these rights and freedoms are subject to reasonable limits. Okay, so the government can determine if there are reasonable limits that can be placed on these freedoms. And people sometimes forget that when they think about these rights and freedoms, that the government can actually infringe on them. But then there has to be a demonstration of need. And that's one of the questions Agamben is interested in. How do you determine what need actually is? And as he finishes chapter 1, he suggests that need is something that requires a subjective determination, not necessarily an objective one. We can give other examples here as well. So we could talk about civil war, economic failure, threats of war. All kinds of things could lead to a state of emergency. Now, before we get into a bit of history here, I thought it might be nice to look at some models of how we can actually think and reflect on the relationship between law and emergency. So in our first model here, this green circle will represent the law, and that's also the case over here. Okay. In our first model, we can think of necessity as being part of the law. Okay, so the X here stands for necessity. And there we go. And some scholars would like to think that the law can spell out precisely when there is a case of necessity and what regulations have to be followed. On the other hand, there are other scholars who say, well, necessity is so different from law that we need to place it outside of the law. It has nothing to do with the law, and we make up new rules which can go against the traditional laws and norms. Now, according to Agamben, different countries have followed these two approaches in different ways. So, for instance, Model 1 is much more common in Germany and France. So, Germany and France. Whereas Model 2 is more common in Italy and England, as well as the US of A. Okay. Agamben himself argues, however, that often these two models are too simplistic and the reality is more complicated. That's why he prefers Model 3 for much of the book in terms of thinking about what a state of exception actually is. In this case, we have law as our first circle and not law or reality or fact. Okay, so we'll call this factum in Latin, as the second circle. And the other Latin word we can use here for law is jus, which can also mean right. So it means either law or right. And then if we think of the state of exception occurs pretty much right in the middle here. Okay, so that's the state of exception. It's both legal and not legal. It's both jus and factum. And it's very difficult to kind of get a sense of what it actually is. Agamben refers to this zone in a number of different ways. So he calls it a zone of indistinction. He calls it a threshold, kind of like when you're standing in the doorway between two rooms. He refers to it as undefinable. And he also uses the terms anomie, so anomie, and aporia, or in the plural, aporias. Anomie refers to basically an absence of law. So this comes from a plus nomos. Okay, nomos is Greek for law. And when you put a before a word, it often means the absence of something, like ahistorical. So anomie refers to an absence of law, a kind of state where there's a breakdown of ethical standards. An aporia is an irresolvable internal contradiction. And you can see that that's the case here in terms of this being both legal and not legal. How do we actually kind of reconcile that? Okay, so that gives us some models to think about then. And we'll come back to the theory at the end of this video, but I'd now like to turn to some historical context as Agamben does in his book as well. So the middle section of chapter 1 is mostly history. And Agamben looks at a number of different countries, but I'm going to simplify and look at the ones he spends the most time on, and these are France, Germany, and the USA. So in France, as we pointed out before, we do have this attempt to kind of spell out in the law to some extent what a state of emergency would be. And first of all, in 1791, the Constituent Assembly's decree, this is a couple years after the French Revolution, this decree suggests that there are these three different states, as you might call them. So we have let me see here. We have an État, and there we go, État de paix, which is a state of peace. We have an État de guerre, which is a state of war. And then we have this third state, an État de siège. Okay, so in a state of peace, everything works normally. The military and the civil governments do their own thing. In État de guerre, they tend to work together. And in an État de siège, the military takes over and kind of rules, and the executive branch of government is really in charge. Okay. Then if we move on to the period after this, we start to see quite a number of different moments where we get further laws that kind of work this out. So in 1797, in 1811, in 1815, these are moments when there are kind of further regulations about this. When we get to 1848, this is the period of the Second Republic. Okay, so the Second Republic lasts from 1848 to 1852. And the Constitution in this period tries to spell out in more detail who can actually declare a state of siege. So at first, the attempt is really to make sure that Parliament declares the state of siege and should do so, especially through a law. And in fact, the Constitution comes out in 1848, and a law in 1849 spells out further requirements for the state of siege. In 1852, we have Napoleon III. Okay, so Napoleon III, who kind of elaborates on this, but adds this provision that the head of state can have the exclusive authority to declare a state of siege. And you can see in the second half of the 19th century this kind of tension then between the head of state and Parliament in terms of who is going to have this authority. Jumping ahead, we get to World War I, and pretty much every Western democracy in this period declared a state of emergency to deal with the crisis, and this allowed for all kinds of things in terms of taking over people's houses, imprisoning people without the same rights necessarily, dealing with spies, right? All of this kind of stuff, and the list simply goes on. After World War I, the state of emergency was often used in France to deal with economic reasons, and we have states of emergency declared in 1924. We have it again in 1935, and also 1937. Okay. Then after that, when we get to just before World War II, we have Prime Minister Daladier, who receives exceptional powers to deal with both the Nazi threat and also with economic matters. So in the period 1938 to 40, we have, again, this kind of state of emergency to deal with these things. Jumping quite a few years later, so this is after the war, in 1961, we have the Algerian crisis. And at that point, President de Gaulle declares a state of emergency by invoking Article 16, which he himself had kind of come up with. Agamben isn't quite sure whether this Algerian crisis really merited such a strong response, and Agamben generally feels that the state of emergency is declared way too easily with all kinds of infringements on the law. Not that he's super in favor of the law either, but we'll get to that later. So then we move on to Germany, and in 1919 we have the Weimar Constitution, and in the Weimar Constitution we get Article 48. Okay, so Article 48. This particular article gave the president incredible powers to declare states of emergency, and during the 1920s and early 30s there were hundreds of these decrees. Many of them dealt with the economic crisis, but we also have, in 1930, for instance, we have President Hindenburg propping up the minority government of Chancellor Heinrich Brüning by giving him this kind of authority where he doesn't have to rule with the whole Reichstag in session, but he can kind of rule the country by himself with his executive powers. So when Hitler comes to power, what he inherits is this kind of tradition where the state of emergency has been declared for almost any reason. Okay? And if we go back to Article 48, it actually said that a law should be formulated which would set up precise requirements for the state of exception. But that law never came into being. So during the Weimar Republic then, during this whole period, we have this excessive use of the state of exception. In 1933, when Hitler came to power, he declared the Decree for the Protection of the People and the State. And what it basically did is it suspended all kinds of articles within the Weimar Constitution that had to do with people's liberty and freedom. But the result of this was not so much to say, okay, well, we're just going to get rid of the Constitution. Instead, the Constitution was still there, but it was suspended. So it wasn't counteracted. He didn't get rid of it. He didn't come up with a new constitution, but he simply suspended it. And the result of this is that from 1933 to 1945, we have basically a continual state of emergency. Agamben actually makes this provocative argument where he says that Hitler is not a dictator, at least not in the legal sense, because he was ruling using the Constitution because the Constitution itself allowed for this kind of abusive power. So that is an interesting way to think then about what happened with the state of emergency and how it enabled Hitler to do some of these things. After the war, in 1949, we get the Basic Law, which is sort of the constitution of Western Germany. And in 1968, we get further amendments where the German lawmakers at the time wanted to include the state of exception again. And the language of this amendment basically suggested that the state of emergency was meant to protect the liberal democratic constitution, which Agamben finds rather ironic. You are basically putting these emergency measures in which take away democracy in order to create or preserve democracy. So those are the kinds of weird aporias or tensions that we encounter in this historical overview. Lastly, we'll have a look here at the US of A. And again, we start with a constitution, in this case 1787, although the full version wasn't published until a year or two later. And in the Constitution in Article 1, Section 9, okay, so Section 9, we have a reference to what is called habeas corpus. So habeas corpus, or the writ of habeas corpus. What this refers to is basically a legal action that allows one to determine whether somebody is imprisoned lawfully or not, right? And that's one of the traditional rights and freedoms, that you can't just imprison somebody against their right to a fair trial. Now, this can be infringed upon or suspended in cases of rebellion and invasion. As we move on then to the American Civil War between 1861 and 1865, we see quite a bit of infringement on people's rights. Abraham Lincoln takes quite a few liberties in terms of imprisonment, censoring the mail, raising an army all of a sudden, all kinds of stuff he does that may infringe on parts of the Constitution. Moving ahead, we get to World War I, same kind of thing as with some of these other nations. In this case, Woodrow Wilson, who's president at the time, oversees the Espionage Act in 1917 and the Overman Act in 1918. And this is probably even stronger language than during the Civil War, where the government can do a whole bunch of stuff in order to deal with the war effort and the crisis at hand. In 1933, we get to the Great Depression, and this is where President Roosevelt at the time uses his emergency powers to deal with the economic crisis and to launch the New Deal, which basically involves these massive public works projects to put people back to work. Then we have World War II. First in 1939, so right in here in 39, we have a state of limited emergency declared, and then we have a state of unlimited emergency declared in 1942. One of the important details here is the internment of Japanese citizens and Japanese nationals. So the internment is something that Agamben looks at. So internment of Japanese people in the United States. And because they have their rights taken away, we can see that this is sort of a blot or a blemish on American history, something to be ashamed of. And in fact, the same thing happened in Canada too, as I know from my own reading in Canadian history. So these are really terrible things that happened at the time, for which we still look back with regret, or at least one hopes we do. So if that happens in a democracy, well, are these states of emergency then actually good and positive or not? This particular history ends with 9/11, and after 9/11, we get legislation like the Patriot Act and further decrees as well, which gradually take away the rights from enemies of the United States, so that we get to the point where the detainees in Guantanamo Bay don't even fall under martial law, right? They don't have access to the Geneva Conventions. They seem to have no legal rights whatsoever. Torture is allowed, all kinds of things can happen. And Agamben, controversially, argues that this is no different than the Jews in the Holocaust in the concentration camps, in terms of their rights being taken away. A lot is at stake then, as you can see, and I think the history is important to kind of sketch out the problem. It seems like as we go along here, increasingly, we see states of emergency used just on a regular basis, and the question is, well, are they still exceptional, or are they becoming part of the norm? I might point out one more thing before we move on. During the first half of the 20th century, we start to see a lot of books being published that deal with this question of what is an emergency and what does this say about dictatorship. So one of the key terms that we see in many of these books is this notion of constitutional dictatorship. Constitutional dictatorship, which sounds like a contradiction in terms. Dictatorship. Okay. This is the idea that we can have somebody in charge who is trying to safeguard the Constitution by suspending it for a time. He's trying to save democracy by suspending the law. Sounds like a contradiction, but that's how many people at the time were trying to make sense of this increasing use of the state of emergency. So far we've looked at fairly recent history, but we can also go further back in time and have a look at both the state of nature and the medieval period. If we think of government, right, so government, and we think of the different branches, so we have the legislative branch, we have the executive branch, and we have the judicial branch. But what if we imagined that these divisions go away in a state of emergency when the government has full powers? Okay, so full powers. It's usually the executive branch which has full powers, and the Latin term for this would be plenitudo, so plenitudo potestatis, or a fullness of power. What would it look like then if the executive kind of took over, right, and took over every part of government? This would look like a kind of fullness of power. And there's a kind of myth here almost, as if we are going back to an initial kind of government in the state of nature or soon afterwards, when there was only a fullness of power, when there weren't all these divisions, but the government just simply ruled kind of like a king who does everything in the wholeness or the unity of his power. And this kind of fullness of power, the term for this is that it's pleromatic, which is a term that was initially reserved or used for God to describe the fullness or abundance of God. So the question then is, well, is that original kind of full power pleromatic, or is it something different? And Agamben much prefers to think about this as more of an emptiness of something, an absence of something. So when we enter the state of exception, we're not entering full powers, but there is a sort of vacuum more than a sort of fullness. And we'll come back to that in future discussions as well. Another thing we can do is go back to the medieval period, and Agamben samples a number of medieval authors, including Dante, Aquinas, and Gratian. And he looks specifically at one legal adage from this period. And this is the notion that necessitas, knows no law, legem non habet, or law not has. This particular legal adage was often used for exceptional circumstances where somebody might take the law into their own hands. So if you think, for instance, of somebody dealing with extreme poverty and stealing a loaf of bread, right? So stealing bread just to survive, then we might say, okay, well, necessity knows no law. Or necessity makes its own law. In this case, it's really important to survive, and we can forgive this person for stealing bread just to survive. Another example, a more technical one here, might be celebrating the Mass. The Mass, of course, had various regulations. It should be celebrated on an altar in a consecrated place, but occasionally, in an emergency, we might actually forego some of these rules. Another example would be a transgression which has already occurred. Transgression, we'll just say in the past. And an example is if there's a bishop who was wrongfully installed, but we find out about this later and he's already in charge, we might kind of say, well, we'll just make an exception and we'll just leave him in his office. We can think of other transgressions too. So think of a child who is a bastard, but the parents later actually get married. Well, that subsequent marriage might legitimize the bastard child. And this is different in different laws in the Middle Ages. So if you look at canon law or civil law, positive law, not every law is going to treat this the same way. The main thing to take away from this is that these are all isolated exceptions. Okay, so these are all isolated exceptions. And that's important. There's no state of exception. So it's not like the government declares a state of emergency which encompasses the whole field and everybody's affected by this. These are really exceptional moments. And in these moments, the law basically stops being binding. So when we think of the law, we have the same model as before. If you think back, we had this notion that the law is here and the exception is kind of outside of it, right? And when it comes to this exception, the law stops being binding. The legal term for this is that it's vis obligandi is gone. Okay, so vis obligandi, this refers to its power or its capacity to bind. And this particular power goes away. The law basically says, well, we'll just ignore that. But these two things kind of stay away from each other. So necessity in this context does not create law. It is itself exceptional, it's unusual. And Agamben's conclusion is that when we think historically, there's a marked break with modernity. Okay, so with modernity, necessity becomes part of the juridical order. So the juridical order. Okay. The law now starts to take the exception more seriously and has to have some kind of relationship with it and do something about it. So then we start to get the state declaring these states of emergency, and it becomes a much bigger deal, not just an isolated phenomenon. If you are interested in medieval history, as I am, I'm trained as a medievalist, you might find this somewhat problematic because often what we see is that the Middle Ages is used as a foil or a contrast to whatever comes afterwards, right? We see this all the time. I do think that Agamben has a point, but there is more to be thought about in terms of the Middle Ages, because I do think that especially this maxim, necessity knows no law, crops up so often and so frequently that people had a lot more to say about necessity than Agamben perhaps gives them credit for. Okay, now the chapter ends with a kind of comparison then of two different models as we think about what this juridical order looks like. And the first model is a little bit like the medieval one, actually. So some scholars, when they think about the juridical order, which we'll just kind of sketch out like this, okay, and if we put the law inside of this, okay, so the law, as you might realize, the law is not the same as the juridical order. If we think of a judge, for instance, a judge is part of the legal order, right, the juridical order, but the judge isn't just simply applying the law in a strict way, or at least not all the time, but sometimes there's a case which is very difficult, and the judge has to make decisions about how this law relates to a case which clearly comes into the orbit or the sphere of the juridical order. Okay, so we have this case here, but where the law doesn't apply all that easily. So when that happens, according to some scholars, we should think of this case, okay, as a kind of lacuna. And lacuna is a gap. There's something missing. So in this case, there's something missing here. We don't have a clear law for this, and so the law just has to deal with this in these exceptional circumstances. But as you can see, from this particular point of view, the law is not really suspended. Nothing extraordinary happens. It's a little bit more like the medieval model, isn't it? Where the law simply has to take into account this particular exception. And Agamben wants us to think about a different model then. So if we kind of sketch this out, here's the juridical order, here is the law, and then we get this very difficult exceptional circumstance. Well, what happens is that the law is kind of suspended, but it's also still there. So we'll put an X through it. It's kind of there, and yet it's not necessarily in force. So we'll call this the suspended law. Suspended law. And there we are. And he refers to this then as a kind of fictional or fictitious lacuna. Fictitious lacuna. Okay. It's fictitious because a state of emergency is kind of made up, right? It's not something that's always clear where you go, yep, that's an emergency, we got to deal with this. Think back to the beginning of this video where we talked about Trump's border wall. That's not an easy one. Even things like a national disaster or COVID-19. It's not easy to decide exactly what emergency powers might be necessary. And so this kind of model, which will be elaborated in subsequent chapters, one of the key things is that it involves some element of decision. You have to decide, okay, if it is a state of emergency. And this decision is subjective. So if we go back to the beginning of chapter 1 now, at the very beginning, Agamben quotes the German critic Carl Schmitt, who is sort of one of the main characters in the book. And Carl Schmitt argued that sovereign is he who decides on the state of exception. Okay, so sovereign is he who decides on the state of exception. In other words, the person or the government that makes the decision declares its sovereignty or shows its sovereignty in making that particular decision. And we can now see that the state of exception is really key then to government, right? And that's why chapter 1 is called the state of exception as a paradigm of government. In other words, the state of exception gives the government a kind of way to show its power, to show its sovereignty, and it underwrites it, it grounds it, you might say. There's lots more to discuss, but I hope that this first video gives you a little bit of a sense of what's at stake and the kind of modeling that Agamben works with here as he tries to figure out how the state of exception actually works.